And welcome to this YouTube channel once again. Uh, this is the current affairs series. It would be the almost last class for polity and governance. In today's discussion, I would try to discuss 7 to 8 articles which are very important for our exams. Most of them we had already discussed, and they are you know uh, they had been upgraded by time when the news is differ and the news came, so they were upgraded according to that. So today we will discuss mostly about the different Supreme Court verdicts, and we would see what are the new laws which came into existence, and what were the laws which were struck down, uh, what were the things which were struck down, and what were amended, and what were brought in new. So, without any discussion, let us jump to the topic directly. It is about electoral bond scheme, which, if you remember, if you are watching my videos since last uh, all of my videos or a few of mine videos, I would have discussed about electoral bonds very often. And you know, as it is very much in the news, it was very much in the news in the last month also. So let us discuss about it. As in as SC, as mentioned here, Supreme Court in Association of Democratic Reforms versus Union of India and others unanimously struck down the electoral bonds. In what happened, the Supreme Court struck down the electoral bonds, usage of electoral bond scheme. So for these elections, for the coming elections, electoral bonds can't be used. So let us see more about the news. Let us about it. First, we should know. We will discuss a little bit about electoral bonds. What does it mean? What are its features? And how it, which bank was associated with it. As by electoral bond, it means a bond issued in the nature of a promissory note, which which shall be a bearer banking instrument and shall not carry the name of the buyer. So it is kind of a promissory note, which we can also, it is a bearer's check. It is a bearer's property in whose hand this electoral bond is. It belongs to that person, as it does not contain the name of the buyer who bought it. So it is. Let us see more about the features. It is issued to a purchaser on a non-refundable basis. If anybody buys this electoral bond, it can't be refunded. It was the main feature of the electoral bond. They were not able to uh, refund it, or refunding criteria was not in electoral bonds, and also could be purchased by citizen of India or a body incorporated in India from authorized branches of state bank. It could have been purchased by a citizen, by some companies or authorities in which are incorporated in India. Let's see where it was used. Could be used as a donation to only registered political parties which secured not less than 1% of votes in the last general election. So we cannot give these electoral bonds to every political party. There was a criteria for it, and the criteria was at least first they should be registered political parties, and the votes which they secured in the recent elections, or we can say in the last general elections, it was the votes they secured were not less than 1%. We can also say a question may be framed like that: can this electoral bond be given to an independent candidate? No. Can it be given to all political parties? No, we cannot give it to all political parties. We have a very defined criteria for it. What was its purpose? Its purpose was to enhance transparency, to stop black money, and all that. Let us see what are the highlights of the judgment and what was the key issues, key questions which were asked by which were asked to Supreme Court, and what were the verdict, what are the verdicts issued by the Supreme Court. If the first question we would the first question which was asked, we can highlight it in simple words here, whether the non-disclosure of information on voluntary contributions to political parties is violative of the right to information. As we know, in electoral bonds there is no information, no buyer's information or recipient's information given. So whether it is does it violate the right to information? It was the first question which was asked, and second question was whether unlimited corporate funding to political parties as envisaged by the amendments to the Companies Act violates the principle of free and fair election. Unlimited corporate funding to political parties, does it violate the principle of free and fair elections? With this record, the Supreme Court gave its verdict, and Supreme Court said electoral bond scheme by anonymizing contributions violates the right to information. It does violate the right to information, which is traceable to Article 19(1)(a), and thus is unconstitutional. The Supreme Court directly said that it does violate the right to information, and it is as traceable as found in Article 19(1)(a), which is a fundamental right, and thus is unconstitutional. Second, and also when electoral bonds were brought in, and there were several amendments made, like amendments made by the Finance Act 2017, to the Income Tax Act 1961, the Representation of Peoples Act 1951, and the Companies Act 2013, to allow donations through electoral bonds have been held to be unconstitutional. All those amendments which were made by the Finance Act 2017, for example, to Income Tax Act 1961, to Representation of Peoples Act 1951, and the Companies Act 2013, about the donations through electoral bonds have been held unconstitutional. Then also about the company's corporate funding, what SC said, amendment to the Companies Act permitting unlimited corporate contribution to political parties is arbitrary and violative of Article 14, which is about equality. So it does violate the equal principle of fair and free and fair election. It violates the right to equality also. About the amendment which was made to the Companies Act about the unlimited corporate contributions. And also the court has emphasized the amendment's authorization of unrestrained corporate influence in elections, which contravenes the principles of free and fair elections and political equality, which I already mentioned. So courts acknowledge that these electoral bonds, they violate their right to information, which is the basic right of the human beings, which is under fundamental right Article 19. And the several amendments made by the Finance Act 2017, for example, the Income Tax Act 1961, the Representation of People Act 1951, and Companies Act 2013, they are also non-constitutional, unconstitutional. And also the amendment to the Companies Act, which led to the corporators unlimited funding, is also against which it violates the Article 14 about equality and free and about equality, and also about the principle of free and fair election. So these were the key highlights of the judgment of the Supreme Court. Let us see further what the Supreme Court further added. What Supreme Court ordered: the issuing bank shall stop the issuance of electoral bonds. The issuing bank here were the authorized SBI banks. So Supreme Court ordered them to stop the issuance of electoral bonds. And also Supreme Court directed State Bank to submit to the Election Commission of India. It is full report regarding electoral bonds since 2019, how much money had been converted through electoral bonds, who paid, and to which party they paid. The Supreme Court uh, State Bank of India to submit its report to Election Commission of India, and also Supreme Court directed Election Commission of India to publish the information shared by the SBI on its official website, and also Supreme Court said that the valid electoral bonds which are not encashed yet must be returned the issuing bank, and it should it which would refund the amount to the purchaser's account. Here, this clause which we already discussed about the electoral bonds, it was non-refundable, but here Supreme Court allowed if there are any electoral bonds which are valid electoral bonds and are not encashed yet, they should be returned and the amount should be refunded back to the purchaser's account. And what further Supreme Court added that the electoral bonds did not proportionally justify to curb black money, as the promoters of electoral bonds said that it would help in curbing the black money, but it did not proportionally justify to curb black money. And right to privacy of a political affiliation is also defined here, that here when the political affiliation, that right would be protected for the providers, and but there should be very well transparency about the funding, where from they are getting, how much they are getting. About the people who are funding them, their rights are protected. It only This right to privacy of political affiliation, it only extends to contributions made as a genuine form of political support, the disclosure of which may curb various forms of political expression and association. It does not extend to contributions which may be made to influence policies. So it does not extend to contributions which may be made to influence policies. This was about the electoral bonds. These discussions were very much important, and this would be the last class regarding these electoral bonds. Till now, I think I had discussed this in many videos. We had discussed electoral bonds many times, and I think the information which is given here should be enough for you. If any question would be asked regarding electoral bonds in the exams, whether in prelims or in your mains, you should be able to answer that properly. Let's move to our next topic. It is as it was the 75th year of the Supreme Court of India, 75th anniversary. So let us see what are the things which we need to learn here, and what are the important points which may be asked in the exam. So recently the Prime Minister inaugurated the Diamond Jubilee celebration of Supreme Court of India on 28th January at the Supreme Court Auditorium in Delhi. It was celebrated at the Supreme Court Auditorium in Delhi, 28th January. These dates usually they don't ask in exams, but it is better to remember. Maybe such questions may be asked in the exam. So let's see what was more about this news. On the occasion, PM launched multiple technology initiatives for the Supreme Court. For example, digital Supreme Court reports. It will make Supreme Court judgments available to the citizens of the country free of cost and in electronic format. And we have Digital Courts 2.0 application is a recent. This Digital Court 2.0 application is a recent initiative under the e-courts project to make court records available to the judges of the district courts in electronic form. And also we have the e-court mission launched in 2013, aims to modernize India's court systems by making it digital and improving access to justice. And also new website of Supreme Court. The new website will be in bilingual format, which would be in English and Hindi, and has been redesigned with a user-friendly interface. So these were the points which we need to remember. These were launched these were launched multiple technologies initiatives for the PM launched multiple technology initiatives for the Supreme Court. Here we discussed about the digital Supreme Court reports. What does it? What will it do? It will make Supreme Court judgments available to the citizens of the country free of cost in electronic format. Then we have Digital Courts 2.0 application. 2.0. This application is a recent initiative under the e-courts project to make court records available to the judges of the district courts in electronic form. Here a question may be asked like that: digital Supreme Court report, what does, and digital courts 2.0, they might be interchanged. That here it is for citizens in a digital Supreme Court report, and the judgments are available for citizens, and here in digital courts 2.0 the judgment is for the district courts, for make records available to the judges of the district courts. So we should remember, we should analyze these points. These are very thin points which we usually ignore, but it has the UPSC has the habit. They often ask questions of those thin lines. So we should remember these things. We should keep this in our mind. What a digital Supreme Court reports, what are the features in it, and the digital courts 2.0. Then similarly we had the electronic court mission, which was launched in 2013. So, and new website of the Supreme Court. Let's move further. Here we have to discuss about the relationship between judiciary and the executive. It would be very brief. As in Article 50 in Part 4, the state shall take steps to separate the judiciary from the executive in the public service of the state. That is, the state they should take steps to separate the judiciary from the executive, so that all they would be independent. There would be least influence. But if since the inception of the constitutions, if we know that these branches have witnessed a conflict due to their encroachment upon one another, we will often see that judiciary, executive, they try to influence in making it. For example, National Judicial Appointment Commission, when they try to bring it on and try to influence the judge selection for the Supreme Court, and it was the breach. It was then discarded by the Supreme Court that here the executive, they are trying to interfere in the judicial domain. And similarly we will see many judgments made by the Supreme Court which were the overreach from them. They are interfering in judiciary. So there is usually we had seen many times tussle between these two departments. Since 1947 and 40 to 64, confrontation began on issues of right to property. For example, Kameshwar Singh versus State of Bihar, the government brought the first Constitutional Amendment Act and inserted the 9th schedule. Political class asserted its supremacy through amendments. Or whenever, for example, confrontation began with the right to property, as is mentioned in this case, Kameshwar Singh versus the State of Bihar. Then when Supreme Court gave its verdict, then the government brought the first Constitutional Amendment Act and inserted the 9th schedule in it, where they tried to safeguard it from the judicial review, by which political class asserted its supremacy through amendments. Then we have second phase, in which is from 1965 to 1993. Due to frequent amendments to the Constitution, the Supreme Court had to assert its position. For example, Golaknath case, Keshavananda Bharti case established the dominance of SC. Then when Constitution were amended many times by the by the parliament, and they asserted their power over Supreme Court, and Supreme Court responded with the different cases. For example, Golaknath case, where they, for examination on the Bharti case, and they highlighted the basic principle, and there was a tussle between, highlighted the basic principle where the government cannot touch that, and they safeguarded their position, and there we can say there was a continuous tussle between, and back and forth between the parliament, or we can say executive, and the judiciary. However, the government responded with the Constitutional Amendment Act 24th and 25th, which restricted SC powers, and they tried to restrict the Supreme Court's powers. For example, ADM Jabalpur case, Minerva Mills case again asserted the position of SC. Then we have from 1993, it is the third phase. In here we have three judges case, empowered SC in the appointment of judges. They try, and we have National Judicial Appointment Commission, which was then struck down by the court. So here in this slide we had seen a relationship between judiciary and executive, and how executive tried to uh, interfere in the domain of judiciary, and how judiciary replied to that and interfered, and they tried to interfere in the domain of the executive. So there was a continuous tussle between the two. There has been a continuous tussle between the two. First, which are described broadly in different phases. As for example, from 1947 to 64, we have one phase where the property right dispute was there. Schedule 9th schedule was inserted to safeguard from the judicial review if any amendment was made, and to safeguard that, we have seen a continuous tussle between judiciary and the executive. So let's move forward and see more about the Supreme Courts, as we would get a little bit information about it, and which would be, if you had studied your polity well, you might already be well knowledgeable about the Supreme Court. So let me recap here a few important points which we should remember. According to Article 124(1) of the Indian Constitution, the Supreme Court of India must have a Chief Justice of India and a maximum of 7 additional judges, unless Parliament specifies a higher number through a statute. So, at the Supreme Court, according to Article 141, the Supreme Court 124, sorry, the Supreme Court must have the Chief Justice of India and maximum of 7 additional judges, unless Parliament specifies through a statute. Currently, Supreme Court comprises of the Chief Justice and 33 other judges. So, what are the constitutional provisions? The Supreme Court powers and jurisdictions are outlined from Article 124 to 147 of the Indian Constitution. Let us discuss about the key features of the Supreme Court of India, which are highlighted in these 6 points. First, we can say it is the highest court of appeal. The Supreme Court is the highest court of appeal and is also known as the apex court of India, and also the last resort, where the citizen of India can seek justice if they are not satisfied with the judgments of the lower courts or the high court. Then we also know that it has the advisory jurisdiction also, as per Article 143 of the Constitution. The SC Supreme Court can advise the President of India that is related to a question of law and the nature of the matter is associated with public importance. Then we have also adjudicate federal disputes. For example, the courts resolve disputes between the union and the state, and between different states, which is mentioned in Article 131. They have the judication to resolve federal disputes. Then they have the power of judicial review. The Supreme Court reviews laws and actions of the executive to ensure they comply with the Constitution. And also protection of fundamental rights. The courts protect the fundamental rights of citizens by issuing writs and orders under Article 32. For example, habeas corpus, mandamus, quo warranto, etc. Then we have public interest litigation. The court can take up cases in its own or on behalf of the public interest. In some matters, the Supreme Court also acts on its own and can pass suo motu. So let us see what are the challenges faced by the Supreme Court. These are the following challenges: massive case backlogs. As of 23, there are over 80,439 cases pending in the Supreme Court alone. Judicial activism versus judicial restraint. This debate resolves around the appropriate role of the judiciary in policy making and governance. For example, when they interfere in the executive matters and where judiciary should not, where there is a line where judiciary should not interfere and where they should interfere. So there is a continuous tussle between judicial activism and judicial restraint. Then we have one of the challenges, uncle judge syndrome. The Law Commission of India's 230th report highlighted a concern about political favoritism in the appointment of judges to high courts and Supreme Courts, impacting the impartiality and fairness of the judicial system. Then we have judicial executive conflict. The judiciary and the executive have faced rising conflicts marked by delays in judicial appointments, the tribunalization of justice, and public criticism of the executive during COVID-19. So, as earlier mentioned, continuous tussle or continuous conflict between judiciary and the executive. Then we have public perception and trust. That is one of the challenge, that there have been concerns about the public perception of the judiciary, including issues related to transparency, accountability, and judicial independence. That how people view our justice system, how people view the Supreme Court, their perception. So it is one of the concern uh, faced by the Supreme Court. Let's move to our next topic. It is about regional benches of the Supreme Court. Here, the Parliamentary Standing Committee on Personal, Public Grievance Law and Justice informed the Parliament about the government's acceptance of its recommendation to establish regional benches of the Supreme Court. So it is about the establishment of regional benches of the Supreme Court. It was informed to the Parliament by its Standing Committee on Personal, Public Governance, Law and Justice. So let us see more about the regional benches of the Supreme Court. Let us see what we have to discuss in here and what is needed. The recommendations were made in the 133rd report of the Parliamentary Standing Committee titled Judicial Process and Their Reform. The recommendation is these about regional benches. Their recommendation is titled under Judicial Process and Their Reform. So, Supreme Court of India may invoke Article 130 of the Constitution for establishing its regional bench at 4 or 5 locations in the country. For example, as per Article 130 of the Constitution of India, the Supreme Court shall sit in Delhi or such other place or places as the Chief Justice of India may, with the approval of the President, from time to time appoint. So here in this Article 130, we have to remember that the presidential approval is very much important to establish the regional bench, and who can establish them? They are established by the Chief Justice of India with the approval of the President. They can be established at 4 or 5 places where the Chief Justice of India may favor in the country. So the interpretation of the Constitution and constitutional matters may be dealt at Delhi, and so what the report further says that the interpretation, for example, if the cases related to the interpretation of the Constitution and constitutional matters come, they may be dealt in Delhi, and the regional benches may decide appellate matters. Other issues may be decided by the regional benches, so that the burden of the cases on the Supreme Court may be reduced. And also the appellate bench's decision should be treated as final, and it should not be treated as another layer of the judiciary. What this report further says that if other regional benches of the Supreme Court, they give any decision, that decision should be treated as final. It should not be treated as another layer. That if, for example, in West Bengal, we can say in the eastern side or side we have one bench and they give any decision, it should not be then transferred to the bench which is situated in Delhi. So what this point here, what this point wants to say you that the decisions made by these regional benches, they should be made final. It should not be treated as that it is another layer of the judiciary which is sandwiching between high courts and the supreme courts and the high courts. So it is decision should be made final. Uh, it should not be further reviewed by another bench which is in Delhi. So these were so let us see what is the need of the regional bench of Supreme Court. Here we have following points in it. We would see what is the need. First, access to justice. Regional benches of Supreme Court would take justice to near to the common citizen, thereby upholding access to justice, which is a fundamental right under Article 14 and 21. So, access to justice would be very easy. It would the Supreme Court would be very much near to the citizens. For example, Delhi, for the people NCR region, it is very easy for them to travel. But for the people from Maharashtra or from eastern northeastern states, they have very difficult to travel to Delhi. So if these regional benches would be made, the accessibility to the courts would be very easier for them, and uh, just justice would be served to them. Justice which is access to justice which is fundamental right under Article 14 and 21. Then also Article 39A of the Constitution provides that states shall secure that the operation of the legal system promotes justice on basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that the opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. You know, usually what happens if, since right now we have only one Supreme Court bench which is situated in Delhi. So for many people, because of lack of money and other disabilities, they are not able to travel to Delhi, and they face cruelties from different authorities. So they are not so much, they are not able to secure the justice. So if these regional benches are made available, so it would be easy for them to ensure the opportunity for any securing justice, and the citizens would not be denied the justice which is the basic right, or we can say which is the fundamental right of a citizen. So it would be easy for them, and very easy for them to secure the justice. Then we had, it would reduce the geographical bias. For example, Delhi centric Supreme Court caused a huge big hurdle for litigants coming from far-flung areas of the country. For example, we have language barrier issues in finding lawyers, the high cost of travel and stay in Delhi, etc. So it would reduce that geographical bias. Then it will reduce the burden of Supreme Court. Also, regional benches can be the solution to the overflowing case load of the judiciary and reduce the litigation cost to the common man. And also capacity enhancement. Permanent regional benches of Supreme Court would lead to an increase in the number of judges in the Supreme Court, thereby increasing the judge to population ratio. So, as we know, every law or every recommendation, whatever it is, will have some challenges. Let us see what are the challenges in creation of the regional benches. For opposition from Supreme Court, the Supreme Court has been consistently rejecting the proposal for setting up the benches of the Supreme Court at a place outside the Supreme Court. Is first we have the most important challenge to it is the opposition from the Supreme Court. Supreme Court itself is rejecting the proposal for setting up the different benches of the Supreme Court outside Delhi. It affects the unitary character of the Supreme Court. Multiple regional benches could lead to more divergent views within Supreme Court, which may become difficult to resolve. For example, if we have multiple benches, they would give different views to the same case, and it would become more difficult to resolve and resolving these issues. And so it would further increase the caseload. Conflicting precedents. Regional benches may lead to the rise of conflicting precedents, resulting in increased litigations, as already mentioned, and might reduce the position of Supreme Court. Regional benches of Supreme Court deciding only appellate matters would reduce the position of the Supreme Court. Then classification of the case, identifying and categorizing a case as being of constitutional significance poses a challenging task, which is, for example, to classify a case which is important for, or we can say a case as being which is important, or we can say which has the constitutional significance, poses a challenge, poses a huge challenge to identify such cases. And also the Chief Justice of India may have exclusive power to determine which case is to be classified as a case of constitutional importance. This also is not good. Here this law can be misused. So this was all about the Supreme Court. Now we have another important article to discuss, which is NALSA. It is the National Legal Service Authority. Recently, Parliamentary Standing Committee submitted its report on review of the working of legal aid under the Legal Service Authority Act 1987. What Parliamentary Standing Committee? They submitted its report on review of the working of legal aid under the Legal Service Authority Act 1987. Let's discuss what NALSA is. NALSA, or the National Legal Service Authority, is an apex organization established under the Legal Service Authorities Act 1987. So we should know that what NALSA is. A question may be asked: is it a constitutional post or it is statutory post? So we should know that it was established under the Legal Service Authorities Act 1987. So it is a statutory post. It oversees the implementation of legal aid policies and programs and monitors legal aid activities across India. The core principle of NALSA in India is to ensure that the impoverished and underprivileged have access to justice through the provisions of free legal service. So its core principle of NALSA is that the underprivileged or poor people have access to justice through the provisions of free legal aid. And also the legal aid under it is applicable to courts, tribunals, and other bodies with the judicial or quasi-judicial powers. It also promotes settlement of disputes through alternate dispute resolution mechanisms. Central government allocates annual funds to NALSA distributed to state and district legal service authorities. State governments cover state level expenses including salaries. So this was nutshell information about NALSA, how it was established under the Legal Service Authorities Act 1987. What does it do? It oversees the implementation of legal aid policies and programs and monitors legal aid activities across India. The core principle, its core principle is to provide free legal service to underprivileged people, and all that which we. How it gets funded? It gets funds from central government, allocates annual funds to NALSA, distributed to state and district legal service authorities. State governments cover state level expenses including salaries. So further we have who are the weaker sections covered under section 12 of the law. They include women and children, members of scheduled castes or scheduled tribes. We have industrial workmen. We have persons with disabilities, persons in custody, victims of human trafficking, victims of natural disaster, ethnic caste violence, industrial disaster, persons with an annual income of less than 1 lakh or as notified by the central state government. So these are the weaker sections covered under section 12 of this law. Let's recap. They are women and children, members of scheduled castes or scheduled tribes, industrial workmen, laborers, we can say industrial laborers, persons with a disability, persons in custody, victims of human trafficking. So all these mentioned victims of natural disaster, ethnic caste, violence, industrial disaster, persons who have annual income less than 1 lakh rupees or which are notified by the central state government, they are these weaker sections who are seen by NALSA. And for them and they provide the legal aid, legal service, and legal aid with legal free trial for these people mentioned here in weaker sections covered under section 12 of the law. So NALSA grants authority to oversee legal aid initiatives to legal service authorities at national, state, district level. We have Taluka Subdivisional Legal Service Committee and High Court and Supreme Court Legal Service Committees. So it grants authority to oversee legal aid initiatives in all three divisions. For example, legal service authorities at national, state, district level, Taluk Subdivisional Legal Service Committee, and High Court and Supreme Court Legal Service Committee. Then, what are the functions of NALSA? Legal and assistance. Its function. It includes advocate representation for the person and process fee payments, document preparation, including drafting and translation, and provision of certified copies of legal documents in proceedings. Then participation in PIL's litigations for social justice on behalf of the marginalized under sections of the Legal Service Authorities Act, the protection of fundamental rights of the abandoned and destitute women, widows in Vrindavan X. The NALSA versus, for example, the NALSA versus Union of India recognizes transgender to be the third gender. So it participates in the PIL litigations. It participates for it protect the fundamental rights for women, and it also helped in recognizing the transgenders to be the third gender. We have its function. We see its function in lok adalts and mediation aimed at resolving legal disputes expeditiously and amicably, thereby reducing the burden on the formal judicial system. We have legal awareness to promote legal literacy. It promotes legal literacy through various means, including seminars, pamphlet distribution, television and radio appearances, internship for law students, and legal aid clinics in colleges, etc. And also it helps in victim compensation through schemes like compensation scheme for women victims, survivors of sexual assault, other crimes. And also it aims to provide compensation and support to women who are victims or survivors of sexual assault or other crimes. So these are few important functions which are under also, for example, it helps in legal aid assistance, participation in PILs, free litigation for social justice on behalf of the marginalized sections. Then we can see lok adalts and mediations for in legal service. PILs that they had helped in recognizing the transgenders as third gender. We see its function in lok adalts and its function in mediations. It helps in promoting legal awareness and victim compensation also. So government initiatives for legal aid. So what are the government initiatives for legal aid? We have DISHA, which is read as designing innovation solutions for holistic access to justice in India. We have Nyaya Bandhu platform, which facilitates connection between pro bono advocates and registered beneficiaries, encouraging pro bono culture among law students, advocates, and law schools. Then we have Tele Law Service, connect beneficiaries with lawyers via tele video conferencing, available in 2.5 lakh gram panchayats across 766 districts. We have Legal Aid Defense Council System, LADS, initiated by NALSA. This question may be asked. Legal Aid Defense Council System, who initiated it? It is initiated by NALSA, ensures efficient legal aid in criminal cases by engaging full-time lawyers across 676 districts nationwide, mirroring public defender systems in developed countries. Then we have Nyaya Mitra program, facilitating disposal of 15-year-old pending cases at the district level through its Nyaya Mitra program, and to empower citizens through Pan-India Legal Literacy and Legal Awareness program. So these are a few initiatives which are taken by the government in providing the legal aid. Move to our The next article, it is about the Article 142. So this is this is very important article which we have to discuss in here. This article gives huge power to the Supreme Court. Because of this article, they are able to overreach. They do judicial overreach. They interfere in other issues. They take cases on suo motu. So let us discuss about Article 144. The Supreme Court recently nullified the outcome of the Chandigarh mayor election, as it was recently in news, exercising its power under Article 142 of the Constitution to ensure complete justice. What is idea of complete justice? This news that Chandigarh mayoral election this is not important for our exams, but what is important is Article 144, the power it gives to the Supreme Court. What is idea of complete justice? The idea of complete justice is derived from the Article 142 of the Constitution. It means to ensure justice by filling gaps in the law and overriding legal provisions when necessary. This entails interpreting and applying laws considering broader constitutional principles, societal needs, and evolving standards of justice. So it means to ensure justice. The main aim of the Article 142 is to ensure justice by filling, if there is a gap and there is no clear provision for any law, then there the constitutional you know constitutionalism is seen, constitutional morality is seen, and constitutional principles are seen, and the Supreme Court decides on those issues and delivers its complete justice. If we would read it in a proper way, it means to ensure justice by filling the gaps in the law and overriding legal provisions when necessary. When it is necessary, it entails interpreting. It gives Supreme Court power to interpret and to interpret any law which has considerable broader meaning, and to deliver its verdict and uh, solve the issue and to deliver the justice which is needed. So it gives a power to Supreme Court wherever it is necessary. They can uh, interfere and promote the idea of complete justice and deliver its verdicts by promoting the complete justice. So let's see more about this article. In under Article 142, the Supreme Court is in the exercise its jurisdiction may pass such decree or make such order as is necessary for doing complete justice in any case or matter pending before it. So where the evidences are not very much clarified, very much defining about anything, so their Supreme Court can extend its power and deliver its verdict and do and try to do complete justice. It enables the Supreme Court to exercise executive and legislative functions in specific scenarios, including issuing guidelines, directives, or orders to governmental bodies or other authorities. So, this law gives a kind of executive and legislative powers to functions to the Supreme Court. For example, it helps in it issues guidelines. For example, when it was COVID time, it issued guidelines regarding COVID-19. It directs or orders the government body is to do specific functions, and also permitted the Supreme Court to intervene in matters concerning public interest. By this article, Supreme Court can enter into any matter which are related to the public interest, for example, human rights, constitutional values, or fundamental rights, safeguarding them against any form of violation or infringement. Also, it elevates the Supreme Court's role as the protector of the Constitution and ultimate interpreter of the law, serving as a catalyst for judicial activism and innovation. So, it was about the Article 142 brief uh, knowledge which may be asked in our exam. So we should remember these points. What the Supreme under Article 140, the Supreme Court in the exercise of jurisdiction may pass such decrees or make such orders as is necessary for doing complete justice. It gives a kind of executive and legislative function to the Supreme Court. It permits the Supreme Court to intervene in matters concerning public interest regarding human rights, constitutional values, or fundamental rights, then elevates the Supreme Court's role as a protector of the Constitution. So, what are the positive impacts of the Article 142? It addresses urgent issues with legislative vacuum. Where there is a legislative vacuum, it addresses urgent issues. Proactive approach, for example, during COVID-19, we have huge legislative vacuums there. How to deal with the pandemic? There, the Supreme Court came up and delivered its guidelines. So, it helps under urgent issues. Proactive approach enables courts to provide remedies and resolution in cases where absence of litigations can hinder the delivery of swift justice and lead to irreparable harm. For example, in Banwari Devi and others versus State of Rajasthan, the Supreme Court provided the Vishaka guidelines to address workplace sexual harassment, eventually resulting in the Prevention of Sexual Harassment Act in 2013. Also, cleaning of Taj Mahal, release of under trials, and Union Carbide case are few more examples of judicial use of Article 140. It also helps in strengthening democracy. It protects the rights of minorities and ensures that all voices are heard and respected within the democratic process. For example, as we saw in case Puthuswamy case, which is versus Union of India 2017, known for its right to privacy, established guidelines for under it. Supreme Court established guidelines for safeguarding individual privacy. So these are more positive impacts of it. It also provides checks and balance. It serves as a crucial check on government branches, preventing overreach and protect citizens. For example, in 2014, the Supreme Court cancelled all but 4 of the 218 coal blocks allocations deemed illegal and arbitrary. It helps in civil rights and social justice by addressing issues overlooked or avoided by the legislative and executive branches. For example, in Vinita Sharma versus Rakesh Sharma and others, the Supreme Court addressed conflicting judgments on daughters' coercionary rights under the Hindu Succession Act. Then it promotes equality by challenging discretionary laws and practices, ensuring equal protection under the law, irrespective of race, gender, sexual orientation, or other characteristics. In the Secretary Ministry of Defense versus, for example, in the Secretary Ministry of Defense Babita Punia case, SC granted permanent commission to women officers in the Indian Army. So these are few positive impacts of the Article 142. Let us see what are the issues with the Article 42. So here we see subjectivity in the definition. While using Article 140, courts has wide discretion, and this allows the possibility of its arbitrary exercise or misuse due to the absence of a standard definition of the term complete justice. Complete justice is not; it is very subjective, and it is not well defined. So here courts can misuse their power. So what is important? Defining complete justice is a subjective exercise that differs in its interpretation from case to case. Also blurs the line between branches. Judicial activism may sometimes blur boundaries between judiciary and legislature, causing confusion in roles. For example, SR Bommai versus Union of India 19, the Supreme Court intervention in Karnataka's political crisis with a floor test blurred judicial executive lines, sparking concerns of overreach. Then we have unaccountability. Article 142 grants the judiciary, unlike the executive and legislative branches, immunity from easy scrutiny or challenges for its decision. So accountability is one of the concern in it. Then we have the power has also been criticized on grounds of separation of power doctrine. Then we have lack of consistency, inconsistent legal rulings under Article 142 complicate litigation planning and operations for individuals and businesses. So these are the issues related to Article 140. Then we have one of the important article here. It is about criminal defamation. The Law Commission, in its report number 285 titled "The Law of Criminal Defamation," has recommended that the offence of criminal defamation should be retained in the new criminal law, which were recently brought in, which replaced IPC. So more about criminal defamation. As per the Black's Law Dictionary, defamation means the offence of injuring a person's character, fame, or reputation by false and malicious statements. So, if we have to know what defamation is, it is the offense of injuring a person's character, fame, or reputation. और किसी के बारे में हम गलत बताएंगे, we spread false rumors about anyone's character or fame or his reputation, then this comes under the defamation. So defamation is characterized into two types: written of libel or oral or slander. Libel is an untrue defamatory statement that is made in writing. Then we have slander. It is an untrue defamatory statement that is spoken orally. Then according to here, what we need to know, that defamation, it is of two types, either spoken or written. When it is spoken, we call it slander. When it is written, it is called a libel. Libel is an untrue defamatory statement that is made in writing, and slander is an untrue defamatory statement that is spoken orally. So UPSC can frame a question from these lines, that libel and slander are associated with what. Here options would be different, and one of the option may be defamation. We should know these things. Libel is an untrue defamatory statement that is made in writing, and slander is an untrue defamatory statement that is spoken orally. According to Indian law, libel and slander both are considered to be criminal offences. Such statements are to be made in public to constitute defamation. So further, as Indian Penal Code section 499 makes it unlawful to communicate any false information about an individual to harm their reputation, and the prescribed maximum punishment is 2 years. However, section 354 of the 2023 Bharatiya Nyaya Sanhita Act states, whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, or with fine, or with both, or with community service. So in IPC section 499 makes it unlawful to communicate any false information, or we can say defamation, and the prescribed punishment is 2 years. Maximum punishment is 2 years. And here in section 354 2 and of the 2000 Bharatiya Nyaya Sanhita Act status, and the defamation shall be punished with simple imprisonment for a term which may extend to 2 years. Also here also we have 2 years, or fine is added in it, or both, or with community service. The Supreme Court India in Subramanya Swamy versus Union of India 2006 upheld criminal defamation, balancing free speech and the right to protect reputation. Law Commission highlighted that the reputation is an important facet of Article 21 of the constitutional right to live with liberty, which cannot be allowed to be jeopardized just because an individual has to enjoy his freedom of speech and the expense of hurting the sentiments of another. As we know, under Article 19 we have freedom of speech, and it is not universal right. It has restriction, and defamation is one of the restriction of the freedom of speech. We cannot say anything about anybody, so we have to same is under Law Commission, which highlighted the reputation is an important facet of Article 21 of the Constitution, which is live with life with liberty. So if we cannot defame anybody, we have right to express, right to free speech, but that does not mean by that right we can defame anybody. Article 19 enumerates grounds on which restrictions on the freedom of speech and expression can be imposed, and one of which is defamation, as already defined. And also, according to data published by UNESCO, 160 countries in the world criminalized defamation.